Hi, and thank you for your interest in the Department of Justice Roleplay and Music and Mayhem Roleplay City. What is Department of Justice Roleplay? DOJ Roleplay serves as response roleplay but can also instigate roleplay. DOJ is about creating performance, influencing storylines, and facilitating drama or comedy. Department of Justice serves as a voice for the citizens, aka its players, of M&M. A case or trial must serve a purpose of RP. And an example of this, if anyone remembers, is the State versus Band-Aid the Alien. What DOJ RP is not. It's not about winning or losing. You will win, you will lose, you will be sad or happy. It's not personal and it's not about you. If you are DOJ, you are passionate, but remember, we're a team, so it's a win-win for everyone. And it's definitely not us versus them. While the citizens may hate the cops and your character may hate the cops, DOJ and law enforcement are two sides of the same coin. Act appropriately and not emotionally. Personal, personal vendetta. You will not use your position to seek personal revenge against other players or entities, such as gangs, PD, EMS, or even the state, or anyone in particular. There are many ways to do your law RP. There are different types of lawyers. We have criminal defense, where you'll handle criminal cases. Sometimes you are the defendant when the state brings a case against your client. Sometimes you are the plaintiff suing the state. Trial lawyers, civilian cases. These are typically going to be citizen versus citizen disputes. Sometimes your client will be sued, making you the defense, and sometimes you will sue, making you the plaintiff. If a citizen sues the police or EMS for non-criminal behavior, then you will go against the state. We have business and corporate lawyers. These are lawyers that represent a business to protect them from lawsuits and create contracts as needed by businesses. You can also merge these together. You could be a criminal defense as well as a business or corporate lawyer. You can be a trial lawyer, but also be a state attorney. You could be a trial lawyer and a, you know, insurance lawyer or something. There's a lot of RP you can do with law. State attorneys are headed by the district attorney. The state attorneys work as a team to defend entities of the state and prosecute criminals. Now, lawyers may also work as a team by creating law firms. You can buy your own property, do your own advertising, um, including, having your own paralegals and whatnot. Uh, really, there's just so much you can do with law RP. Okay, so criminal attorneys, also known as criminal defense. When flying into the city to perform duties, we suggest that you put out an ad on Yellow Pages and or Twitter letting people know you are in the city. I would also suggest sending a message to cops via the job app stating lawyer and your name is in town for defendants. You would also need to make sure you check the job app or Twitter to see if anyone has been needing a lawyer in the few hours before you've gotten there or flown into the city. Reminders, you are there to enhance RP and create RP. This scene is about your client. If you are called to the jail cell or to police department, just remember that most people arrested are guilty. But if you think the police do not have a case and truly lack evidence, or you think you can explain away evidence, push for a trial. If you think there is no way I could win this, but the circumstances are kind of entertaining, push for a trial. If you don't think there is enough evidence for a trial, but the citizen is still wanting a trial, then you will need to reach out to a judge and the state for a bench trial. If the situation doesn't meet any of these criteria, do your best to facilitate RP to make it worth the criminal and police's time, negotiating for reduced time or investigating to see what the police might do for the criminal. At this point, you guys have probably been there for a while. If the police are saying no, 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 There's no reason for them to do that. They should be also RPing with you guys as criminal attorneys, and I believe the police are aware of that. Other things to know. There should be no reason for law enforcement and lawyers to get into arguments over personal things, even in character. Saying, it's my character when this is your job is not a valid excuse, and that goes for both lawyers and law enforcement. You are there as DOJ to determine if you should take it to court, and if you decide this is a no-go at court, then negotiate between client and police over time and fines. The police should be role playing as well, as I said, and not just telling you no, no, no. Any decrease in time or fines is a victory. If a client gets too personal or combative, OOC, not contributing to the scene, then finish the scene best to your ability or call for backup from another lawyer if in city. If that person calls you again, you have the right to refuse service to that citizen and tell them why. Just say, the last time you called down for an attorney, you were very combative, and I don't feel like I can properly defend you. And just move on with that. Tell them find another attorney or, sorry. Pre-trial. So if you guys decide to go to trial and everything's, this is what would happen. Setting trial in motion. Someone files a complaint and gets a lawyer. You'll find out at this time if you're the plaintiff or the defense. If someone's filing a complaint and you're the person they're filing a complaint to and they're like, I want to sue, you are the plaintiff. You are the person who's going to bring a case against another entity in a court of law. The defendant is the individual, company, or institution being sued or accused in the court of law. At this time, you're going to file a docket, and it's not like a normal docket that's super long. We call it a docket just to say we're filing a docket because that's what you would do in a normal law setting. It's literally just a who, what, when, where, why of why we're having a court case and or who is being sued. Um, we have a copy of this right here, which will take you to a hyperlink. You'll need to make you'll click file and make a copy, writing your case on it. For example, you would do BCSO versus your mom or your mom versus your dad. And then you'll fill out all the pertinent information for the plaintiff. So if you're the plaintiff, BCSO is suing your mom, and here's all of our evidence, and here are our witnesses. At that point, if you are the plaintiff, make sure the other side has a lawyer and suggest one if it's not the state. If it's another civilian, citizen, or business, they get a lawyer. If they're state or government agencies, they get represented by the state attorney's office, which is run by the DA, who may or may not take the lead in that case, but will also have other state attorneys who can also lead the case as well. Once the other side has a lawyer, you will present the docket to them. Plaintiffs must provide all evidence against the defense. The defense only has to provide a witness list. Once the list is provided, the docket goes to completed documents, and it's in our Discord that you would be invited to, and you would at the judge and also at the lawyers involved. So yourself and the other representing lawyer. The person who completes it or puts it in there is going to be the defense lawyer who puts that in there. Non-starter RP. There are a lot of things we won't do as far as role play. Cases should not be about anything SA related. And if you don't know what that is, then Google it. Sexual harassment, SA, anything related to rape should be a ticket issue and not a storyline. If someone is being harassed or feels uncomfortable in the city, then that should be a ticket and it should not be DOJ unless um, like harassment, stalking, not sexual harassment, but other types of storylines, as long as it's, like I said, stalker storylines must be mutually agreed upon and not cross lines from IC to OOC. The same goes for serial killer storylines, which should technically be approved by the government because they need to know, hey, why are you just RDMing? You know, they're not RDMing, they're doing a serial killer role play. Okay. Domestic abuse. While we are a semi-serious server, the drama should be creative and not reflective of real life trauma. Racism, and we shouldn't have to explain this. Band-Aid was a species case and created for RP. He was a literal alien from outer space about to be deported from the planet. Um, that is why that storyline happened. It was strictly for RP, and we already knew who was going to win. What is evidence? This is actually probably good for not just DOJ, but also our citizens to be aware of what the DOJ will consider evidence. And yeah, so body police cam footage. No citizen has body cam footage, you guys. Nobody. Even if you say, oh, I've got body cam footage. No, you do not. Nobody has GoPros in the city. The only people who have body cam are the police. So, and there are no CCTVs either. I've seen people try to do that. There are literally no CCTVs. The only CCTV footage I believe we agreed upon is in the police department. So you have to be physically inside the police department to have CCTV footage. That is the only place in the city that has it. Police must provide body cam footage to either side. So plaintiffs, defense, everybody gets a copy of the body cam footage. We have in-city tech. We have cameras that actually take photos. They're really cool. They're $10,000, but they have we have physical proof of that way. We have phone recordings. We have video recorders. If you're streaming, use these emotes. I have myself in these various poses. You can use J Selfie 5, J Camera Big, camera, record. Sometimes in other people's eyes, you will not see the camera, but you'll see them in that pose. And also, you're going to be sharing it. So we can see that you've obviously have used the emotes and you are physically in the act of, recording. You can't sit there and say slash me, whips out video camera. You have to physically be doing one of these emotes. Um, we've got Instagram posts, we've got Twitter posts, stories, news articles. Anything can be used as evidence as long as you can, from your streaming, or if you're using Metal, you can turn that into like a screenshot, screen recording, and just, present that as evidence to your lawyer for stuff. Also, if you have witnesses, try to remember who was around you and also say, hey, would you mind being a witness for me in my trial? And let your attorney know as soon as possible. All right, in providing evidence, video and photos or recordings, in preparing to present evidence, all evidence must be turned into a video and uploaded to YouTube. Each video must be clearly labeled as to what it is, and don't do Exhibit 1 or Exhibit A. You have to put, example, your mom stabbing the judge or your dad holding a knife. YouTube videos need to be at least 1 minute long or they become a short and not a video. I would suggest using the app InShot, CapCut, or something like that to turn photos into videos in order to upload them to YouTube. Once you have your videos, then the judge or judges will create a chat to link the videos and the chat for you to call upon when you are doing your evidence. And at that time in court, you'll say, could the court please pull up evidence labeled "Your Mom Down Bad"? You must provide this evidence a day before court. It is your responsibility to remember your titles for the court to pull up. So don't sit there and say, hey, can you pull up the evidence of Torrid standing over Band-Aid with a knife in her hand? when it's clearly labeled towards crazy. Like, just try to remember your titles, write them down, and yeah. How many witnesses can I have? Okay, so we have learned that so that the trial doesn't drag on. Unfortunately, the more people involved in the trial, such as defendants or plaintiffs, is going to like pretty much tell us how long the trial is going to be, unfortunately. So if there are 7 plaintiffs, then we'll need 7 defense. And if there's going to be 4 character witnesses for the plaintiffs, that's 11 witnesses. So now the defense may have up to 11. Doesn't mean you have to have 11, but you can have at least up to 11 doing it. Now, if you have 11 witnesses and there's 4 plaintiffs, you want to go through your witness statements and determine whether or not who has the best like account of version of events that will help your defense or your team, I guess is what you would say. Um, in that case, you can, if you say, hey, look, I have 5 and I know the plaintiff only has 4 witnesses, but I have 5, that's great. Uh, just, work it out among the 2 uh, lawyers and say, hey, look, I'm going to have 5 witnesses. I know you have 4. Are you fine with that? For sake of role play, we most than likely, we should be saying yes, go ahead. But if I have 4 and you're going to give 12 witnesses, no, absolutely not. Like, we should be equal or as close to equal as possible. So how courts should go. We're going to have an intro by a bailiff and the judge. So the intro is the bailiff is going to read the docket up to where it says evidence. We don't want people to know what the evidence is. We just want to know, why are we here? At that point, the judge will then say, and reintroduce if they want to say, hey, we have plaintiff, so and so, and defense so and so represented by, the state, and say the state attorney's name, represented by the defense and the defense attorney's name, um, you know, do that. And then we'll have opening statements. Plaintiff will always go first. Now, the plaintiff goes first and they are setting the scene. Why are we here? And here's the reason, and it's all this person's fault. Is pretty much what you want to say in your opening statement. Defense will then go, and defense is pretty much outlining their defense, their strategy. It couldn't possibly have been us, and here is why the plaintiff is wrong. Like, this is why. Then you'll call the witnesses. The plaintiff, again, plaintiffs go first. And typically for your plaintiff, the first witness you want to call is the plaintiff themselves. That sets the tone of the story. Why are we here? Why are you filing, this court proceeding? Why are we here on your behalf? And then um, you'll have the other witnesses come to bolster the story. After each witness comes, they'll be cross-examined. So say you have the plaintiff, then questions end. They stay there because the defense gets to cross-examine. At any time um, the defense says something that makes the plaintiff like, ooh, contradict something that might hurt them, at that point, after the defense has done their cross-examination, the lawyer for the plaintiff can then redirect. It's the same thing. Every witness will come, cross-examine, you can redirect. There may be times where you don't redirect. It's just like, well, crap, what are we going to do? There's nothing we can do about that one. Or you don't have a way, you just can't think of anything off the top of your head. There's going to be a lot of ad-libbing. Sometimes you'll want to, for your witnesses, you'll want to make notes. Like, here's a line of questioning we're going to go. You're not coaching them. You're just giving them, hey, here are the points that I'm going to talk about. You need to have an answer for it. Hopefully it goes our way and you don't say something you shouldn't. So yeah, Then after all the plaintiff witness, all their cross-examination, all the redirects happen, then we've got the defense coming up. Now, the first people you're going to want is you're going to want your other witnesses. They're the ones that are going to tell you what happened, what they saw. And at the very end, you really want your defense, the person who's the defendant, you want your defendant to go last typically. And you want your defendant to go last because they're like your drop mic situation, like how, all your other witnesses are bolstering and defending your defendant. And then your defendant comes up and says, it couldn't have been me. Now, at the same time, it's the same thing's going to happen. You're going to have cross examination, redirects, and all of that. If you get confused by it, I can always use, I don't know, dolls or something and talk to you guys about it. But it's really cross examination, redirect, blah, 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 blah. Then, after all the witnesses go, there's no surprise witnesses or anything. There's nobody who's feels guilty and jumps in the crowd and says, I'm the real murderer. Like nothing surprising happens. You'll go to closing statements. At that point, plaintiff will go first and then the defense. The plaintiff is going to pretty much reiterate what they've learned. Sometimes your closing statement will change by the time you get to closing because you've learned stuff in the trial and then you're like, oh, I need to reiterate this, like drive this home. Then the defense will go and they're again reiterating how it couldn't possibly be them or why they're innocent and they should be found, not guilty or whatever. At that time, judgment will go to the judge. We would love to have jury trials at some point. We did try a jury trial. Unfortunately, we felt like it was not clear and it was not it was biased. So we're hoping one day to have a jury trial, but right now all sentencing goes through judge. And the judgment will happen if there's sentencing, say like, hey, I went to a bench trial. The same thing would happen with the bench trial, except it's a little faster because there's not a lot of witnesses and whatnot. And then you would be sentenced, or if you're found guilty, there's sentencing, fines to be paid, and stuff like that. So pretty. During trial, at any time, attorneys, you may object. That doesn't necessarily mean that the judge will, allow it. So when you object, the response you will get from the judge, and the witnesses must allow the judge to respond, as well as the attorneys must allow the judge to respond, sustained or overruled. If you are overruled, the judge is allowing the question to continue. If it is sustained, the judge is saying, nope, go on to the next question. So there's different types of objections. So in regards to testimony, this is for you can actually object to your own. So if you are questioning someone and you say, objection, Your Honor, non-responsive, you need to say the witness is not answering the question. And this means the witness is either not actually answering the question or the witness is purposely providing a non-response. And this is, like I said, the person asking the question can actually say this, the attorney, or the other attorney could say non-responsive. They're not answering the question, objection. Like, what are we doing? Relevance is one of my favorite ones. Is the evidence isn't relevant or what the witness is saying is not important. They could say, have a witness up there saying, oh, I was there, at the recycling center when, who cares? That's not where the evidence, it took place at a Fleeca. What are you talking about the recycling center in Pulido when something happened at a Fleeca in Los Santos? Like, what are you doing? Objection, lack of foundation. Just because you shoot a gun doesn't mean you know how it's made. And that's an example. So if you say, I was up at the recycling center. Okay, well, tell me how many mats does it take to create, um, you know, a gun or extendo? Just because you're at the recycling center doesn't mean you know what materials are used to craft. You may not be a crafter. You may not, like, you don't know. You're just like, hey, I just recycle things because I worry about the environment. So that's a lack of foundation. Hearsay, it's rumor, it's not firsthand account. You can't sit there and say, well, I heard from so and so that he shot his baby mama. Like, you have to be the one who saw it. You can't be the one who heard about it. Other ones we have. So you also may object to questioning. Um, Objection, argumentative. A lot of this is going to happen during cross-examination, so you have to be ready when they're cross-examining your client or your witnesses. And argumentative is the attorney is drawing conclusions. This also will probably go with leading as well, asking a question in a way to suggest an answer or provide the answer in the question. So you have to really watch for those. Objection, argumentative, and leading. Um, it could also be then if they have to rephrase the question, if they say, sustained, they'll rephrase the question. Typically, that ends up being objection calls for speculation because the witness cannot guess or speculate why and how. Like, why do you think they're wearing a ponytail? Was it so they don't get blood on them? Like, calls for speculation leading. Asked and answered, asking the same question, rephrased to get the same answer or a different response. This happens a lot when someone is confused. So or they just don't know how they're trying to get an answer. They want a specific answer and they're not getting it. So you have to just object. Object, asked, and answered. Vague and ambiguous. What the hell are you asking? Pretty much is it. What is the attorney asking? What are you talking about? Um, Also, it could be almost hand in hand with non-responsive as well. So yeah. I know that was a lot of information. Hopefully you understood it. I'm sorry if you didn't. It's really not that hard. It's just here to have fun. And remember, you are a character. You are not yourself. Yes, we take parts of ourselves into the city, but I am MK. I am not spirit. But if you would like to join us in the city, feel free to contact Spirit Story in city or through the Discordia and say, hello, District Attorney Spirit Story. I would like to be part of the DOJ and talk to you about being a part of the DOJ. That would be awesome. All right. Thanks, guys.